All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us for Preserve and Protect the Dependency Record for Appeals. Before we introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you register, you're going to receive a copy of the recording from Zoom within about 24 hours. In that email, you will receive the link for the YouTube posting. You will also receive the CLE code and a link for the materials as well. If you didn't have a chance to register and you need to tell other colleagues, make sure to let them know that we do post these on YouTube, and we also will be updating our website where we have our monthly series information as well. This training was approved by the Florida Bar for 2 general CLE credits, 2 Appellate practice certification credits, and 2 juvenile law certification credits. I'll announce the CLE code towards the end. I'll drop it into the chat. And as I said, it will also be included in the email and in the YouTube description. If you need a certificate of attendance for this webinar, please email me after the webinar is done. As I always say, I like to let them pile up so I can try to get them done at a time. So if I don't send you the certificate after you request it, please feel free to email me again. I may have uh, uh, forgotten to send it to you. So questions and answers. You will see during the presentation that we will have segments for questions. Please use our Q&A feature on the toolbar instead of the chat for questions. Ideally, you can use the chat for comments or feedback, but try to use the Q&A for questions. You will see, you will be prompted to ask questions during the presentation. So this training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I will also drop a link for their website in the chat box, and it will also go out via email. So before we pass it over to our speaker, I'm going to pass it over first to Robin Rosenberg. Robin is the Florida Children's First Deputy Director, Chair of the Children's Rights Work Group for PILS, and the mastermind behind this monthly training series. So Robin, the floor is yours.
Thank you, Jorge. Dayna, can you flip to the next slide, please? So welcome everybody to our monthly training series. We started this last September, and our plan is to go the third Wednesday of every month with topics we think are of importance to attorneys and other folks who work in the child welfare system. We don't always talk about what Florida's Children First is all about, so we wanted just to share with you what our mission is and some of the ways that we try to accomplish improvements to the child welfare system for kids and with the kids in care through our colleagues at Florida You Shine, who are current and former foster youth and young adults experiencing homelessness. Next slide, please. So hopefully all of you by now who are lawyers are members of the Florida Dependency Law Center. If you are not, I highly encourage you to register to use the Florida Dependency Law Center. It's a free online legal resource for attorneys and judges who are members in good standing of the Florida Bar. There's all kinds of resources and opportunities to communicate with colleagues, and it's a way that we can stay in touch with everyone with upcoming events and changes to the law. And so we hope that you'll join us. Most of the topics that we do for this series are broadly applicable to folks who work in the child welfare system, attorneys and non-attorneys alike. And we always welcome non-attorneys, our GAL volunteers, case managers, independent living workers. Everyone is welcome to the entire series. This topic today is a legal it's a legal seminar. It is highly case specific. And if you're not a lawyer and you feel like it's over your head, feel free to sign off. This is just a warning. I've never had to give this warning before. It's going to be hugely beneficial to attorneys. And if you can stick with it and listen, you all can help the attorneys that are working with parties on your cases to help them protect the record. But just your heads up in advance. I am so pleased now to turn it over to my colleague, Dayna Maeder. Dayna rejoined Florida's Children First in December of last year. I'm so excited that we have our own appellate attorney. She brings great resources to all of our daily work, in addition to representing children and young adults herself. So Dayna, the floor is yours. And thanks everybody for being here.
Thank you so much, Robin. It's been a pleasure to work with you as well and with FCF. I'm so humbled to be able to present this today. That was a beautiful introduction. I'd like to just start briefly by letting everyone know today's agenda, and then I'll jump right in. So for segment two, because I called the introduction segment one, so it already looks a little funky, but segment two, we're going to talk about standards of review and building the record. Segment three, objections, standing objections, and proffers. And then segment five, let's see here. I called it potpourri, and really I have three main segments within segment five that I think are important. I don't think we'll have enough time to get to them today. So if you're looking at the slide right now and you see one, either A, B, or C, that really speaks to you and you'd like to learn more about, please do drop it into the Q&A, and so that we can take a little informal poll to see what everybody's interested in. And with that, I'll start with the standards of review and building the record. We will have a handout hopefully later that will give you some of the key case law where I found the content that I'm going to share with you today. Rest assured, it is all foundationed in authority and rules and statutes, including some that just recently updated this week. And without further ado, we will talk about the standard that governs most of what you'll fight about, which is competent substantial evidence, or CSE. When an appellate court reviews factual findings, is there anything that the judge decides is true? Any of the findings that they make, including whether someone is credible, including whether something is relevant, all of those in an adjudication or a termination, the appellate court does not reweigh that evidence, doesn't find it more or less likely to be true. The Supreme Court put it this way in Re MF, which is 770 Southern 2nd 1189. A dependency ruling is a mixed question of law and fact and will be sustained on review if the court applied the correct law and its ruling is supported by competent substantial evidence, which the court called tantamount to legally sufficient evidence and called it highly deferential. It's one of the only areas of law that is given that highly deferential title. So it's really pretty difficult to overturn. And as the court is very serious about it. So just 2 years ago in the GAL versus CC, and I'm not going to give you all of the citations. I will give those to you later, or if you especially need one. But this is versus CC. It quashed a district decision for reweighing the evidence on least restrictive means, saying the court should have simply reviewed for competent substantial evidence. So the theme for this whole CLE is if the standard is deference to the fact finder, your appeal really is won or lost at trial, because competent substantial evidence means you build the record below. You get your evidence in, you keep the inadmissible evidence out, and you make your sufficiency argument on the record. And we'll talk proffering a little later on. It's one of the keys that I see missing a lot in the trial level, that it really is something that the appellate courts take seriously. So the second standard is de novo, which is Latin for of new, essentially. And so pure questions of law, statutory interpretation, legal sufficiency of the grounds, constitutional issues, those get no deference to the trial court at all. The third district said plainly in CR versus Department of Children and Families, the standard of review for a question of law in dependency proceedings is de novo. It's not a mixed question. And in FC versus DCF, for termination specifically, it's de novo. So the way the fifth DCA framed it in another case is the one to me to remember. The case is DE. The appellate court is not required to defer to the trial court when there's no theory or principle of law that would support the trial court's conclusions of law. And this is very, very different than a fact, right? There's not any kind of standard where, hey, if the court thinks there's no principle to base that on, if there's evidence in there and the trial court could have found it, that's it. De novo is completely different. Constitutional challenges live here too. The parent's right is, as the Supreme Court says, a fundamental liberty interest protected by both the Florida and federal constitutions. And that's our Florida Supreme Court in a case called DCF versus FL. And then there are cases that probably everyone's heard of, Santosky, Troxel. Those are the federal courts, the U.S. Supreme Courts that say the same thing. And so statutes burdening it get strict scrutiny, right? Do you remember that from law school? Those are reviewed de novo. So the record lesson is the opposite of the last standard of review because legal and constitutional issues are de novo. You preserve them with specificity, not evidence. Okay, so you'll frame the constitutional argument explicitly, preferably in writing, and get it on the record. And when in doubt, always do a notice of filing. File a memorandum of law. File a notice of filing something that doesn't get in, right? That way it's in your appellate record, even if you weren't able to articulate it below. Abuse of discretion is the third standard I'm going to talk with you about today. This governs rulings that decide how your client actually lives day to day, evidentiary calls, visitation, placement. And the test is actually a family law case called Kanakaris. And it says discretion is abused only when no reasonable person would take the view adopted by the trial court. And then combine that with the highly deferential standard that we're given to the trial court. And it becomes very, very difficult on appeal to work within abuse of discretion. So that's a steep hill. So the record move here, you must build a record that makes the ruling look unreasonable. You put the contrary evidence in, you make the judge's reasoning explicit on the record. But notice where the discretionary rulings get reversed. It's almost never on the merits of the discretion, it's on process. So there's a case last year in the second district in AS. It held a parent's due process rights are violated when the court modifies visitation, this is a quote, without providing the parent notice and an opportunity to be heard. In JJ, the fourth DCA called entering a permanent guardianship without an evidentiary hearing fundamental error, which means it can be brought up for the first time on appeal. And in MG, the second DCA reversed because the court changed placement without taking best interest evidence. Excuse me. So if a party moves quickly for whatever reason, it could be a genuine, wonderful reason, but if procedure is not followed, you must record the objection. And here's how seriously the courts take this. Florida's newest court, the 6th District, requires appellate counsel to include a separate section in its briefing titled Statement of Preservation. And that's within the initial brief. And for every single issue, you have to point to where in the record it was raised, where the trial court ruled on it, and then the standard of review. And so I want you to think about what that means for the trial level. Appellate counsel literally cannot brief an issue unless you've made that record. And as of June 11th, so not even a week ago, 2026, this is no longer just a 6th DCA. The Florida Supreme Court amended Florida Rule of Appellate Procedure 9.210 to require the same thing statewide. So effective September 1 of this year, every initial brief in Florida must contain, for each issue, a citation to the record, right? An actual page number that you can provide to the court. To the appellate court, where the issue was preserved in a statement of the applicable appellate standard of review, plus they ask for a new jurisdictional statement. And so that is Supreme Court 2025-0241. And like I said, it came out June 11, 2026. So the 6th DCA piloted it back in 2023 when it first came out. And now it's a rule for everyone. So preservation and standard of review are now a briefing requirement, and truly it's the trial attorneys who will do the heavy lifting there. If you do know an appellate attorney or there's one who works with you, it's great to talk with them and review some of those while you're live, going through the litigation in real time so that you can preserve those things if needed. So there is another standard. It's not really necessarily a standard. It's more of I call it a wrinkle in the process. And it's the mixed questions and the clear and convincing wrinkle. So in a termination matter, the trial burden is clear and convincing evidence. That's in 39809 sub 1, right? In that statute. So does that mean in the appellate court reviews more strictly? No. And this is the single most misunderstood point, I think, or maybe not the single most, but a big misunderstood point in TPR appeals. And the 3rd District clarified it in a case called IT. It says, even though the state has a heightened standard of proof, our standard of review is unchanged. So what the appellate court actually does is a 2-step. And you might remember this from law school too, the 2-step. But a 2-step process, it asks whether the record contains competent substantial evidence to meet the clear and convincing standard. And per the en banc, that means the whole court decided together in a case called DJS out of the 1st DCA. It will not overturn unless no one could reasonably find such evidence to be clear and convincing. So that tells you how high that burden is, how high that wall is once the findings are made in trial court. So the mixed question piece is a little crack in the wall, essentially. The facts get the deference, but the legal conclusions, most importantly, that least restrictive means, are reviewed de novo. So you can see both halves kind of operating together in a case last year. It was called LW. And if you look that up, you'll see how that works in practice. So the strategy is to fight the facts at trial, where deference is fatal on appeal, and then preserve the legal sufficiency of grounds and least restrictive means as legal questions so you can get that fresh look. Moving right along to statutory findings. Um, Standards of review tell you how the appellate court will look at a finding, but the next piece will tell you which findings the statute requires in the first place. So we'll run the hearings in order. At shelter, 39.402 requires written findings on removal, record supported reasonable efforts determination. The fifth DCA has reversed where the finding wasn't supported. And then arraignment's procedural. There's no findings duty, but there's a case called BY that reminds us every step must comport with due process. So there's your legal question. At adjudication, we're back in the statute at 39507 and Rule 8.322, or 332, pardon. They require a written order stating the facts that support dependency. And that need only briefly state fact drawn directly from the evidence, but it must exist. And then at disposition, right? 39.521 requires a written cannot safely remain at home determination, reasonable efforts finding. Judicial reviews, permanency are, not the same, of course. And the courts have reversed permanency orders entered at judicial review hearings. And then at permanency, we're following that 39.621 sub 8 that says the reasonable effort findings must be explicitly documented and stated in the court order. So that's your friend here, because skipping even one of the 6 statutory factors there, a case called BP said that's a departure from the essential requirements of law, causing irreparable harm. And at termination, the order must evaluate all 11 NBI factors. And last year, a court held an order invalid for failing to do exactly that. So keep a findings checklist at your table. A lot of people will do that on their legal pads. Or on their computers now. When the proposed order is missing a required finding, that's your issue. And then we have this one that's short and sweet, hopefully, the oral pronouncement versus written order. It's technical, but your clock starts for your appeal when the judge actually enters its written order. Rendered means it is in the record. That little number that's on the top left side when it gets put in, that's our rendered date, not the date of signing, not the date of the oral proclamation from the bench. So Appellate Rule 9.020H says an order is rendered when signed, written order is filed with the clerk. Court minutes aren't enough, even if they're signed. Filing is its own separate step. So the oral ruling is not appealable and does not start the clock. I actually had one that took 2 years, requests, updates. The court had not entered this written order. So although there was an oral proclamation that was very clear in court minutes, we could not appeal. It's, an anomaly, but it happens. So read every proposed order, read the transcript, and in dependency and TPR, just know a motion for rehearing, unlike in the civil realm, does not toll your time to appeal. The one motion that can toll a termination is the 8.530 IAC, the ineffective assistance of counsel motion, and that has very, very strict grounds. That just has the rendering happening on the 50th day or whenever the IAC order is issued. But if you are unsure, you can file a notice of appeal early. You cannot file one late. So if you file an early notice of appeal, it will be either kicked back for it being premature, or you can ask for it to be held in abeyance. There are some options that you have, but a late filing means that the appellate court never gets jurisdiction, and that's something they can't make a decision on. And so the appellate court cannot extend its own deadline. And then I am almost out of time for this segment, but the last one I want to talk to you about is capturing off the record moments. And that essentially is everything that we've said so far about these standards of review assumes there's a record to review. And luckily, in dependency court, everything is pretty much recorded. But anything that isn't, the trial court's decision carries a presumption of correctness, and the burden is on the appellant, the person who wants to appeal, to demonstrate error. And if there's no transcript, if there's no error on the face of the judgment or the order that you're trying to appeal, that's it. It's upheld. So if there's a hearing where you have an indigent party or someone who cannot get a record, or there's some sort of fault with the recording, you need to get that on the record. And there's ways to do that. If the judge goes off the record for a sidebar, for example, when you come back on, you can summarize. For the record, at sidebar, the court ruled X and I objected Y. Because if it isn't transcribed, it just really doesn't happen. There is a tiny caveat here. There is a stipulation option. That's in the Juvenile Rules 8.255. And there's also an appellate rule 9.200 sub B5. You can restruct a statement of evidence, and it has to be stipulated. And if there are any objections, a trial court will resolve those objections. So if you and opposing counsel remembered something differently, the trial court will have that ultimate decision on what gets brought up to the appellate court, or if it does at all. So those rules are important because they give you a little bit of a relief if something doesn't get recorded, but it's subject to objections by the opposing party and the court's ultimate decision. Whew. So with that, I will take a sip of my water and open it up if we have any questions.
All right, there's one question in the Q&A. I'm going to read it out loud for the benefit of the audience. The question is, if a judge changes visitation at JR hearing, would that be considered proving a parent the opportunity to be heard, even if no motion to change visitation was filed?
So my initial inclination as an appellate attorney, if you came with me or to me with that question, I would say absolutely. I would say I have not seen anything in my history of work that has said depriving someone of notice and opportunity is okay in a certain situation. Um, that opportunity can sometimes just be stating that you object and that's it, or having your attorney present as your representative and that's it. So it can be a very narrow notice and opportunity, but to do something under a covert, um, uninformed hearing is not allowed. Even in family law, I'll give you kind of an example there. When there are ex parte motions because of harm to a child, or it would be dangerous for the other parties to hear about it. That is one of the few times where a court could make a decision, but they are required within 7 to 10 days. I can't remember exactly what it is, but within a very truncated time to bring everyone together to give that notice and opportunity belatedly. So there's never a time where it's curable without giving notice and opportunity, even if it's after the fact for an emergency reason.
Right, here's another question that just came in. The question is, would visitation modification be a writ of certiorari, I guess?
I love that question. And because I only have 1 minute left before the next segment, I'm going to ask you to hold that one because I have a whole section on certiorari. So we'll get to that. And I love it. That's a wonderful question. Are there any more questions at the moment?
No
Okay.
other questions. I'm going to leave that one as unanswered, and I'm going to also drop in the chat. I'm going to drop a link to the materials where you can follow the slides as well, and the handout as well. So back to you,
Thank you.
Dayna.
Thank you so much. All right, so the next is objections, standing objections, and proffers. And I know you're eager to hear about cert. That's just a little further down. So next we're going to get into how to kind of preserve your record a little more in depth. And the first thing are contemporaneous objections and specificity. So we just spent 15-ish, 20 minutes on how appellate courts review your rulings. And so now I want to talk about how to keep those rulings reviewable. That's a tongue twister. It starts with the contemporaneous objection rule, and it has three parts. There's a case called Harrell, which talks about a timely objection, a stated legal ground, and then the ground you argue on appeal has to be the same ground you raised below. So if you miss any one of those three, your issue's gone. And so here's why the quote, objection, Your Honor, by itself can rarely save you. There's a case called Castor that we all rely on quite frequently. It says the objection must be specific enough to apprise the trial judge of the putative error. And This is so interesting to me because in family law, so I do prior to working with FCF, I did a lot more in the family law, and sometimes my work does still overlap. I have a couple of family cases that, at Florida Children First as well. But I did a lot of family appeals, and we watched the evolution over the past few years of how the appellate courts have tightened this idea. And essentially, what happens is if you don't give the court an opportunity to correct itself, an opportunity to understand what it got wrong, the appellate courts are reluctant and now are having some rules that say they're unable to um, send it back. So if you don't give the trial court an opportunity to do what it needs to be done in the course of the litigation, when everyone is there, when everyone has a chance to discuss, when everyone has a chance to correct, when you've got your witnesses, your exhibits, the trial court's attention, if you don't do anything there, the appellate court is very constrained to then kind of make the whole, tell everybody that we're going to remand back and have you do it again. So the rules are getting tighter, the opinions are getting a lot stricter. There's been a really big movement for tried by consent, which is where if someone brings up something, even if no one, previously knew that it was going to be brought up, not by motion, not by anything, if you go ahead and try it without objecting, then that is considered consent. So this is really, really important. So objection rarely saves you because it must be specific enough to apprise a trial judge of the error. So a bare groundless objection, meaning just saying the word objection essentially, is vague, without weight before an appellate court. And you can't switch horses on appeal. So the case law tells us that arguments on review must be this is a direct quote, specific contention asserted as legal ground for the objection below. So this bites in our world because in a dependency case, the mother's hearsay challenge was waived because the ground in her brief was different from what the attorney said at trial. So the discipline here is simple, it's unglamorous. You name the rule and the ground out loud every single time. Objection hearsay, 9802. Objection improper predicate. The specific words are your preservation, and don't be afraid at maybe sounding silly if you think there's two or three. Make your record. Give us those two or three on appeal. And so one preservation point that I think is kind of a trap, it depends on where you practice, but to challenge the sufficiency of the evidence that someone didn't prove grounds, you have to move for a judgment of dismissal at trial. Juvenile Rule 8.525H says in a termination, and then 8.325 says in a dependency. So there's rules for both. Now there's a circuit split here, or excuse me, a district split here. So in the first district, the motion is mandatory. Back in 2002, the first DCA said failing to move leaves the court constrained to affirm. So when it says constrained, it does not want to affirm, but it's saying it has to. So there was a case, it's called PR. That's that first DCA case. And so there's another case called OT, and it tells you it's not once but twice. So at the close of the petitioner's case, and then at the close of the respondent's case. So if you miss either, the first DCA says your argument's gone. The fourth DCA disagrees. In HD, it held the motion isn't required because in a non-jury case, the judgment itself implicitly rules on sufficiency, right? Because the trial court's saying, no, this is sufficient, I'm ruling. So to me, that's logical, but that's an outlier. So the conflict between those courts was certified, meaning the courts recognized that there was an issue that they disagree, and they asked the Florida Supreme Court to please resolve it. And the Florida Supreme Court declined to do that. So right now we do have a split. I would advise you to always do it twice. What does it hurt, right? So know your district. When in doubt, make your motion twice. It will cost you nothing, and it's the difference between a merits review and getting a constrained to affirm. And don't confuse this with the findings rule. That one's preserved by a motion for rehearing. This is the motion for judgment of dismissal at trial. All right, and so next we're going to talk about, I'm sorry, my notes are frozen. Here we go. Contemporaneous objection and specificities. We're going to talk about standing and continuing objections. So, I mean, we all know you can't just pop up and object to every question. You're going to annoy the court. And in extreme cases, they may even threaten a sanction if you're driving them crazy. So use a standing objection, but you need to use it right. And sparingly, right, when it really matters. So the Supreme Court allowed this standing objection as a litigation tool in a case called Corona. The judge said to the trial attorney, the trial judge said to the trial attorney, assume you have a standing objection to this line of questioning. And the court, the appellate court of the Florida Supreme Court, held that that preserved the standing objection for the remainder of that line of questioning. Good. But a standing objection will only cover that specific ground and the specific content that you identified, nothing more. So there's a cautionary tale in a case called Ivy, Ivey. Counsel asked for a vague continuing objection to assorted things. That's a quote. He just said, like, objection to these things, something like that. And the Florida Supreme Court said the trial court could have no idea what he meant. So that objection preserved nothing. Nothing. And here's the trap. So in Carvey State, the court said if you say no objection when an exhibit is offered, even though you won a definitive ruling earlier, you abandon the objection. So don't think that, oh, I objected earlier, now it's coming in. I should say no objection because the court already knows. You basically undo your objection from earlier. And there's a case called Montauk, I believe, Montaque. And it says in the concurrence, this is a quote, subject to and without waiving my previous objection, no additional objection. So that is a way to preserve your objection to a piece of evidence coming in later after you've made an objection. So there's two habits here that you should get into. Pinning the scope of your standing objection on the record. And if there's something within the standing objection that's different, right? If one is on relevance and then there's a hearsay within it, make sure you specify. And then never say no objection just because a court earlier overruled that. Even though I gave it to you in the example of a piece of evidence, I would say that would go for any type of objection. When in doubt, no, that sounds awful. I was going to say when in doubt, object. Don't overdo it. But when you think there's something there that's reasonable, make sure you have it on the record for your appellate attorney to use. And then we'll talk about proffers and offers of proof. And oh my goodness, there's so many times where I have read a transcript and literally shouted out loud, "Where's my proffer?" So I'm going to flip the coin here. So the objection preserves what the other side puts in, but the proffer preserves what the court keeps you from putting in. So when your evidence or your witness is excluded, an objection is not enough. Section 90-104 sub 1b says you cannot predicate error on excluded evidence unless its substance was, quote, made known to the court by offer of proof. It's a very specific requirement. The Florida Supreme Court explained why in a case called Finney. Without a proffer, it is impossible. This is a quote. Without a proffer, it is impossible for the appellate court to determine whether the trial court's ruling was erroneous. And the first DCA drives it home in a case called Martin. Without a proffer, there's nothing to review. Quote, let alone a fundamental error. So no proffer can sometimes mean no appeal. And it can feel awkward when an opposing counsel's objection to your content is sustained, but it's your job for your client to insist. And the court will understand that. The court knows. So two ways to make that is the gold standard would be a question and answer proffer. Ask the court to allow you to put the actual testimony on the record. And then you would just do it as if it was your actual Q&A with your witness. But a shortcut is a narrative proffer. And there's a case called Holmes, and it holds that an oral offer may be sufficient, particularly if there's no dispute as to what the evidence would have been. But again, you have to be careful what district you're in because the third DCA is more strict. They say a sustained objection and a denied sidebar does not excuse you, attorney. You must affirmatively ask leave at the close of direct and make a specific proffer. So it kind of gives you another idea. Like even if you can't do it right then in the flow of what's going on in litigation, do it at the close of direct. So when the stakes are real and you have a live witness, you must do the Q&A proffer. When you can't, you make a detailed attorney proffer and get opposing counsel. Well, you don't necessarily have to do this, but best practice would be get opposing counsel to confirm the substance on the record. Yes, that is what the person would have testified to, or yes, that's my understanding of the content of this exhibit that got left out. If they don't, that it's still okay, but that's better, especially when you have to do your summary. So as for documents, mark them, which is my next point. Charles Earhart, which was my guiding star in law school for all things evidence, he at one point gave me his phone number so I would quit bothering him in his office. But I love him, and he has a big treaty on this. It's the FLPRAC Section 104.3. But he calls this the professional statement of counsel. It's very official, it's very needed. It's used throughout the appellate process to fix what's broken on the trial level. So when you don't do it, you really do constrain the record on review. Let me see here. The next thing we have is marking those exhibits. So this is a quick one. Documents have their own version of proffer, which is marking it. When the court excludes an exhibit, and sometimes the court will do this for you. They'll say, oh, we're gonna, we'll just mark that for identification purposes, and sometimes they don't. So you need to make sure that happens. The third district said excluded documents, quote, should be marked for identification with a number and described fully in the record. That is what makes them available to the appellate court. The consequence of skipping it is unforgiving. So, in a case called Gellin, counsel failed to proffer the excluded documents or mark them for ID. So, quote, they are not part of the record on appeal. And the issue was dead. So, even though those were sustained objections because the person didn't proffer, there's nothing the appellate court could do. The reassuring part is I think the system's built to help. So if you do that mechanical step under Appellate Rule 9.200 sub A1, the clerk must transmit, quote, all exhibits that are not physical evidence. So a document you tender and get marked refused or, rejected, it'll still write up to the appellate court through that rule. The first DCA confirmed that in another case, DeBose. But in your directions to the clerk that you file on the trial level, it's a good idea. It's good practice to specifically request these to be included. Sometimes clerks think that they're being helpful and they might take something out or overlook something. So it's a good idea to list them specifically in that notice to the clerk, or excuse me, directions to the clerk. Um, there was a catastrophe, I called it. I mean, it got remedied, but in another case where the initial brief was due the following day, not me, thank goodness, opposing counsel, and they noticed that none of the exhibits had actually made it in the record at all. So they had to move to supplement and push it back. So there are things you can do if the clerk leaves them out, but there isn't anything that can be done if the trial attorney leaves them out. So your checklist is hand the clerk the exhibit, get it marked for identification, state on the record what it is, why it matters, and then check the docket to ensure it's recorded, because sometimes that happens too, and make sure it's in your record. And then finally, in this section, I'm going to talk briefly about fundamental error as a preservation backstop, because I think everyone's heard that term before, fundamental error. It means something is so intrinsically wrong that it doesn't matter what happens, something has to be fixed, right? So there might come a day where you realize too late you didn't preserve something. And if it's big enough, there is an avenue. Fundamental error lets the appellate court reach an unpreserved issue. So that bar is deliberately high. Okay, the error must go to the foundation of the case, and the courts apply it very guardedly. And it's reserved for rare cases. These are all quotes in Florida Supreme Court cases. So which key fits that lock in our world in dependency and for TPRs? Due process. Okay, so that's that notice and opportunity to be heard that we just talked about with that wonderful question from earlier. The third DCA held that the denial of due process constitutes fundamental error that may be raised for the first time on appeal. And that's the very slim way that parties can win on issues where there were no objections, when the court terminates on grounds that maybe were never pleaded, when a private adoption somehow morphs into maybe a Chapter 39 termination without notice. That happened in a case called AMVDS. Or when a petition is dismissed without a hearing, that happened in TS. But there's, of course, there's always a but. In a case called BT, there's a holding that fundamental error must actually be harmful. If the court determines that striking the error wouldn't change the result, so it doesn't meet a requirement for being fundamental. So depending on what side you are on, if there's a fundamental error question, you would either need to be prepared that that will be what the opposing counsel argues back, that it wouldn't have changed the result because of this, laundry list of content that the court could have relied on. And then conversely, that would be what you would do if you want to preserve the ruling. So the takeaway for the whole segment essentially is preserve, preserve, preserve. And on the day that you didn't, see if there's a denial of due process or something so fundamental that it goes to the heart of the case. And now with that, I will open it up to questions.
Don't see any new questions. We do have the one from earlier, so if anybody wants to drop additional questions, this is a good time to do so. Checking the chat just in case. All right. I mean, I don't see any questions posted, so you can continue on. And if anybody missed the question, they can still use the Q&A, and we'll try to address those towards the end.
Absolutely. And I do have some time at the end too, just in case for that. So if something pops up where you're like, oh, earlier, does that apply? Feel free to ask me. Um, take one more sip of the water and then we'll get into interlocutory appeals. And I'll tell you a little fun anecdote. The first time that I had a job outside of law school, my first assignment was determining whether something was an interlocutory appeal, and I had never heard that word in my life. And I was trying to understand what was being asked of me, and I ended up with, if anyone on here knows me, like a 20-page research paper on interlocutory appeals to help me through it. Because if there's two things I love, it's research and writing. So I learned a lot about interlocutory appeals and how helpful they can be. And this will feed into the cert question that somebody asked later, because if something doesn't fit into an interlocutory appeal, which is a non-final appeal, it's in the middle of a case. If something doesn't fit into an interlocutory appeal or a plenary direct appeal, plenary mean, it's final. Sometimes people call them plenary appeals. Sometimes they call them direct appeals. That's the appeal at the very end of the case where you're appealing everything that goes wrong in the final order. So if something doesn't fit into these two boxes, then we get into certiorari world, which is that question from the earlier segment. Excuse me, one more step.
So, Dana, one question actually came in related to the previous segment, so I
Sure,
figured
absolutely.
I will go ahead and ask it. The question is, how should an attorney respond to a judge's command to stop objecting? You're interfering with the flow of the story.
Absolutely. So that happens a lot. And that's where you ask for a standing objection for the specific reason. And then once the court grants that, you say nothing else until that section of testimony is over, unless there's a separate objection. So that's when I was mentioning, for example, if you're objecting to hearsay, for example, somebody's telling a story about what a police officer told them, and you've objected to hearsay a couple of times. Every time they say the cop said, the cop said, the cop said, right? And you're like, objection, hearsay, objection. And the court's like, that's enough. You ask for the standing objection to hearsay for anything that the police officer said. You're done. You've preserved it. However, if the police officer starts asking, within this course of testimony, if the person said, and then he started asking me about this topic, and it's a completely irrelevant topic, you still need to bring up your objection to relevance. Objection, Your Honor, relevance to this. Whether they sustain or overrule, then you say, okay, and I probably said that a little bit clunkily, but my standing objection still stands, or something like that, just to kind of keep it in the flow of the record. So my advice and my understanding of how I've read case law and reviewed transcripts is, once you make that standing objection, once you see that it's going to be kind of an ongoing thing, you make it, you sit down, as long as you've identified that it's a standing objection to that specific reason. I hope that answered the question.
Right, I think there is a follow-up, so let me go ahead
Sure.
and make sure I read it out loud. So, Following up on the question, when a surprise change in visitation occurs at JR and parent objects, someone always says visitation is always at issue at JR. And there goes the objection. How do you get around that?
That's a great question. If I think that's a very dependency specific situation. Um, I think my immediate response would be if that's what is the typical response, then you as an attorney would need to be prepared for that to happen. What will an appellate court do there? Because I haven't had that issue on appeal. I don't know. Because technically, right, looking at case law and looking at how the courts handle something like that, there is no notice and opportunity if something had not been previously presented as going to be heard at the hearing. But if you're at a hearing specifically where that is at issue and that can change, then it probably would ultimately be your responsibility. And I think the other side could argue that on appeal convincingly that you were there, you were able to object, and that should be enough because then you can do your follow through. So on a typical tried by consent situation, that would not go. Like I said, when something morphs into a completely different matter that wasn't noticed at all, right? Like when that adoption hearing turned into a Chapter 39 termination, literally within the middle of trial, right? That's something that I think would trigger the fact that that wasn't tried by consent and there was no due process. But if it's something that's in the course of an ordinary type of hearing, and you would have the opportunity to correct with a post-hearing motion, I suspect it wouldn't be enough for an appellate court to reverse. Again, I'm one person, and that's my take on it from an appellate position. It looked like I can't really see on my screen, but it looked like something else popped up. I just want to make sure there's nothing else before I go on.
Yeah, one more just came up. I'm just gonna read it out loud. I'm not sure if it's a question or a comment, but I'm gonna read it out loud. So it's, if your grounds change, is it best to make sure the new grounds are placed on the record and state it is your obligation to ensure effective assistance of counsel? Those magic words can cool the judge's heels.
Yeah, I absolutely agree with that. So not only must you put it on the record if there's a new ground or a ground that you didn't previously raise and then you realized you needed to. Um, I think saying, trying to be effective counsel is great. I don't see why you wouldn't say that. That isn't necessarily the reason that you need to for appeal, but it certainly might help if you are faced with an IAC motion. I like that comment slash question. I'm going to get into these interlocutory appeals. This is a shorter segment anyway, and then when we get to that Q&A, if there are any more, we can continue. But first of all, there's something interesting here, and this happens a lot when people come to me on day 29 of the 30-day window to appeal. And that is what a final order is, because there is a 30-day clock in the appellate world, and it's different in dependency and juvenile rules versus a typical appeal for other types of litigation. And so we've covered how to build the record, how to preserve, and then when you actually do go up, which is what we call it, when you raise everything for the reviewing court, for the appellate court, um, through which door do we go? And we're going to start with the final order. So independency, termination of parental rights, whatever, when you're in the juvenile world, that clock is 30 days from rendition of that final order under Appellate Rule 9.110B. And it's jurisdictional. So if you miss it, the appellate court can't help you. So if you miss a deadline to file something in the appellate court, if you even miss your briefing deadline, there's ways around it, right? You can ask for forgiveness. You can try to file it belatedly and ask them to consider it timely filed. You can request extensions. You can even do notices if you agree on extensions with the other parties. But what you can't do is ask for them to honor a belated notice of appeal. Jurisdiction is not something that they can choose to override. So the Supreme Court has a case in it's called GLS, and it tells you not to cut it close. The quote is, encourage parents to initiate an appeal at the earliest reasonable opportunity. The appellate courts don't have the authority to grant themselves jurisdiction if you miss the window by even a minute. I have a dear friend who missed a deadline, a jurisdictional deadline. It was I think it was like 14 minutes. It might have even been seconds, you guys. It was heartbreaking because that was it. 11:59:59 is the appellate court clock cutoff. It is East Coast. It says East Coast in the rules. It's our time. It doesn't matter where you are in the world. Um, so there's the trap that I flagged back when we were discussing rendition. In dependency, a motion for rehearing, unlike all the other civil matter litigation that's out there, a motion for rehearing does not toll your time to appeal. So that's in Rule 8.265B3. The fourth DCA in Baby Boy L dismissed an appeal, file 54 days out for that reason. In ordinary civil practice, that motion buys you time because it tolls the rendition of the final order, which is the same thing that your IAC motions do, right? It tolls the rendition for a small amount of time, not indefinitely. But in other cases, not dependency, it'll toll the time until they rule on your motion for rehearing, but not so here. So you still need to do your 30-day notice of appeal or your appeal within that 30-day window. So the motion that tolls the termination order, okay, like I said, is the Rule 8.530 IAC motion, and even that must be filed within 20 days of the written order. And it's even deemed denied at day 50 if there's no order, and then that's when your trial order is then rendered. So calendar your 30 days from the written signed filed order the moment it lands. And like I said, I usually push it a little bit. I don't go, oh, there's a weekend, oh, there's a holiday. Just get it in. And then do not let the rehearing motion, of course, lull you into thinking that the clock has stopped. And I'm just going to very, very briefly, because this actually, I get this question a lot. It's not really a huge deal for the purposes of appeal, but for you, in practice, reconsideration motion. There's no rule, there's no statute for that. That can happen at any time. You're just asking the court to reconsider something it did before. You can file that whenever. You can file it aimed at an order that they did 3 or 4 months ago, as long as you're still within litigation. Reconsideration is just asking the court to reconsider something that it's done. You can even aim it at something that happened orally. Reconsideration is very different than rehearing. Rehearing is aimed at only a final order and typically tolls the clock, obviously not here, but that's where you get kind of some of your objections, and sometimes you can use that to help with preservation issues. So sometimes I say kitchen sink it, just throw everything in there that you think you may have even missed, so that you can have it on the record for appeal in some form. Now, the weight it's given is a little lower if it comes in that way. The trial courts, the appellate courts tend to not treat it as it would a contemporaneous objection that you do, within litigation, but it's a way to throw that in there if you need to. Give me just 1 second. Okay, trying to keep an eye on my clock here. So this one's a little funky, and I looked it up, I read it. I'm going to tell it to you. If you ask me questions on it, I might not have an answer for you today. I could keep researching it. It was a little bit of a newer one for me, but I noticed it coming up again and again when I was researching this topic. And it was calling it one of the most common timing mistakes in dependency appeals. So you can appeal too early. We talked about that. An order adjudicating a child dependent isn't final. The Florida Supreme Court tells us that. The adjudication is reviewable together with the disposition order. So you may raise dependency in an appeal from the later order. And that's typically how appeals work, right? You get your final order and then you raise all your issues that happened throughout trial in your appeal once you get that final order. And then if you do file early, there's case law that says a premature notice is just held in abeyance until entry of the dispositional order. And I see that sometimes with IAC motions. People will go ahead and file a notice of appeal, and that rule actually has like a little part in it about if you file early. And not that you want to annoy the courts and have a jurisdictional thing where they're having to kind of go back and forth, but I mean, gosh, when in doubt, just file your notice of appeal. So on the other hand, this is a dangerous one if you appeal too late because perhaps you assumed the real final order was still coming. There's a cautionary tale in a case from the first DCA, JRB versus DCF. The father waited. The clock had already run from the final order. He thought he had more time based on his post-order motions. The first DCA said, quote, his failure to appeal timely ended his appellate prospects. And then just last year, the third DCA, um, though this concept exists throughout Florida jurisprudence, but the third DCA said you cannot trust the label on the order. So nomenclature doesn't save you. If the court calls its order something weird, but the content is of final in nature, it's a final order. And like I said, there's tons of case law out there on that. So in SM, a document titled disposition didn't actually end judicial labor, so it was reviewable by certiorari. But in BD, a disposition order that adopted a case plan and ordered an evaluation, a mental evaluation for a parent, was final and appealable. Same label, opposite answers. So that doesn't mean file a notice of appeal right after adjudication. It doesn't mean file it after every order. But if you're in doubt and you file a notice of appeal and the appellate court alerts you that it's non-final, it if it doesn't do it on its own at that point, you can just request abeyance and relinquishment of jurisdiction back to the trial court. But the appellate courts are very good at that. They'll notice it. They'll say they'll either issue a show cause order for you to show them cause why it's a final appealable order, or they'll say this isn't one. But we're going to treat it as certiorari, or they'll say this isn't anything for us and kick it back. So it'll work with you if you file something too early, not if you file something too late. Let's see here. Common law cert. Here we go. So if a final appeal isn't available yet, can you take an interlocutory appeal? Usually no. Non-final or interlocutory appeals are limited to the closed list and appellate rule 9.130 sub A3. But the instinct is to grab the family law custody provision. That's used a lot. That's sub AC, or excuse me, A3C, Roman numeral 3. A3C3. But the Supreme Court, in a case called Honeycutt, CUTT, closed that door. It says child dependency proceedings under Chapter 39 do not fall within it. And Rule 9.146, our dependency appellate rule, doesn't help because the court said it provides no exception or expansion to the appeals permitted under 9.130, which is the interlocutory, non-final order excuse me, appellate rule. So what that leaves you with is one narrow appealable non-final order and one workhorse alternative. The narrow one is Rule 9.130 sub A3CX, like X marks the spot. That lets you directly appeal an order establishing a permanent guardianship under Section 39.6221. Everything else, my understanding, is the post-adjudication pre-termination zone. Placement changes, visitation, intervention, reunification. Those are non-final and they're reviewable only by cert, not through this interlocutory appeal process. So, and when I say cert, that's certiorari. We just say it because it's a big Latin word. So the decision tree is simple. If it's on the 9.130 list, yes, final and non-final appeal within 30 days of the rendition of the order. 30 days is your clock. If no, your vehicle is certiorari, which is where we'll go next. And remember, if you do a motion for reconsideration aimed at a non-final order, that doesn't toll your clock either for your non-final appeal. You still have your 30 days. So let's talk about cert. Common law certiorari and dependency, it's your safety valve for these non-final orders that you can't appeal. In dependency, you have the potential to use it quite consistently. As you mentioned before, I'm sure you've seen it, but it's hard on purpose. The test, appellate attorneys prefer to do non-final versus cert because cert is a heightened requirement as is, and then you're in dependency, which is also heightened, so it's just heightened on top of heightened. But it can happen, and when it does, it should, right? So the test is from a case called Parkway Bank, a departure from the essential requirements of law causing material injury for the rest of the case that can't be fixed later on appeal is prime for cert. And here's the key. The last two parts, the irreparable harm parts, are jurisdictional. And so they're analyzed first. So sometimes, you can be strategic about how you present your matter to the trial court. The appellate court, because if you can fix it on plenary appeal, the court never even reaches whether the judgment was wrong. And departure isn't just ordinary error. It's quote, something more than a simple legal error. Um, our case is Kaklamanos, Kaklamanos. So the winning cert petition in Dependency lives in a handful of recurring buckets where the harm truly can't be undone. Um, like cat out of the bag cases. So disclosure of confidential or privileged Chapter 39 records without an in-camera review. That's from a case called Alberto. Guardian ad litem v. DCF, which I know it's a hard case to look up. It's a fifth DCA case. I can provide that later. They were compelling a parent's psychological evaluation without good cause, um, granting party status or intervention to someone who shouldn't have it. Um, these are all cert issues. So the court skipping a required hearing or statutory findings before changing placement, denying reunification, those can be brought under cert. So the third line is irreparability. When you draft, I would lead with why waiting for the final appeal is no remedy at all, because that's what you have to defeat that jurisdictional issue, and that's the tight one. Um, when it's just a case, I don't want to say just, but when it's only a case plan compliance gripe, that kind of thing could be raised on plenary appeal. It could be fixed, even if it means that you haven't had time with a child, for example. That can be made up. They believe, and that's not irreparable harm. So there is a little bit of I don't want to say you'll lack credibility because I don't think that that's true. But if you misuse or overuse the courts, there's only a few clerks in each DCA, and they get to know you. And I had one call me, the sweetest clerk in one of them, and she's like, "Did you mean to file this? Because you put the wrong case number." And I'm like, "Oh my God," or I put the wrong excuse me, rule, and I was like, "Oh, you just saved my life. Can I please refile?" She goes, "Sure, I'll reject this." And so they'll do you favors. They're very kind. They look over everything. But they also know if you are cert happy when you shouldn't be, or if you're sending them a ton of work that you shouldn't be. And so I think that you really have to be thoughtful about using cert, but dependency is a place where it lives. So certiorari has four sister petitions essentially. There's um, writs of mandamus, writs of prohibition, writs of habeas corpus, and writs of quo warranto. And when I say writs, what you're doing is you're doing a petition for a writ of certiorari, petition for a writ of mandamus, you're petitioning the appellate court. And interestingly, when you do a petition, you have to do the entire thing you don't do a notice of cert and then you wait for a record and you do all this. Your 30 days to do that certiorari petition or that mandamus, whatever have you, you only have 30 days to do the entire thing. Your whole entire document, 30, 40, 50 pages has to be submitted within that 30 days. So it is a tight window. Um, I know we're a little bit over, so I'm going to go through these rather quickly. They're not used as often as cert. Cert is the big guns, but mandamus that compels a clear legal duty. The court has no discretion to refuse. So if there's a clear legal right, an indisputable duty that the court has, and there's no other adequate remedy, then you might need to force your court's hand. You have to be careful because you're mid litigation with this court, right? But if there's like a required hearing and it's not being said or something that the court has to do, and it's gotten out of hand, you do have a remedy. Prohibition is, I call it the mirror image, but it prevents the court from acting where it lacks jurisdiction. So it's kind of like the other shoe. Now, prohibition needs to be done before the court acts, because if it does do something that it shouldn't do, that can still stand, and then it just applies to future court action. Um, so it stops the court of doing something, not undoing something that was already done. Habeas corpus goes to unlawful detention or placement if a child is removed and sheltered without lawful authority, or if a person's held past what the law allows. Habeas contests that legality directly. Habeas corpus is of the body, so it's a legal way to say hey, state is controlling my body. They're not supposed to be. And then quo warranto is hardly ever used. I was the Florida Bar Appellate Fellow under a board certified appellate attorney, and he said his whole decades long career, he's only had to use it, I think, once. Um, Quo warranto literally means by what authority, and it challenges an official who acts beyond the power the state gives them. It's mostly used politically. It is not for judges or courts. Those are mandamus and prohibition. And then I have one more. I think I'm pretty over on this section, but this is my last section before we get to kind of the potpourri. So I'm going to go ahead and tell you this. Um, and this kind of goes to my credibility point. Just because you can seek review now doesn't always mean that you should, unless waiting will forfeit the issue entirely. And there's two doctrines that we have that kind of pull in opposite directions. On one side, irreparable harm will push you to go now, right? Understandably. Um, like in the third DCA and RR said, if a case plan goal flips from reunification to adoption, that could be irreparable harm because reunification services can stop and you can't get that back. Same with an unlawful placement. There's a case called AH, or a placement transferred to an adoption entity without a hearing, where the second DCA and MG said that deprivation is ongoing and it cannot later be rectified in an appeal from a final order. So those would be taken up immediately. But on the other side, mootness can erase your appeal if you wait. So for example, once a child turns 18, courts have said the dependency question is moot, full stop. And the court refuses to save it, even under a doctrine called capable of repetition doctrine, which means it could happen again and again and again, because that doctrine only actually applies to that same party. So essentially, even if the court got things completely wrong and messed up, if the kid turns 18 and that the dependency issue there is then moot. And then there's a case called Kaplan. It was brought by an adoption entity, and it shows how an issue can evaporate when a bigger ruling lands first. So there were competing appeals in that case. There was an intervention appeal by that adoption entity that the court decided became moot the moment the termination was affirmed. So even though maybe things happened incorrectly below with this adoption entity and whatever, I don't know the complete details and I can't begin to speculate. Even if that was completely wrong, once the termination appeal happened and it was finalized, it was done. So capable of repetition can be one of your escape hatches, evading review, collateral consequences, but those are so narrow and they don't usually work, but they can happen in extreme cases. The collateral consequences argument, like I said, it's still mostly built by analogy, so it's not anything you can really bank on. So map your timing early. Ask for every adverse non-final order. Is the harm from this one truly unfixable later? Will my issue still be alive if I wait? And with that, I hope that I've answered your cert questions. And but if you have more, I'm here for you. And then if anybody has decided what they might like to hear for my final segment, if not, I have a few things that I think this group might like. But I'm ready for questions.
Right. So
And
this,
I was just going to say,
sorry.
Dana, Jorge can issue a poll about picking the topic. He was able to upload that if you want to do that.
Oh, great. Okay, thank you.
I was gonna say about the polls, and we also have a question that came in. I think it was answered, but just asking it out loud just in case. Would a corrected final judgment extend the time to file a notice of appeal?
That's interesting. That's a great question. So, yes and no. If the correction is substantive in nature and it raises a new issue, or something that could be appealable, then yes. If it is purely administrative, clerical, non-substantive, then the argument is that no, it doesn't. And I will tell you, not in a dependency case, but in a different appeal, I actually did this and I argued that it did not toll the time because there was nothing substantive that changed and I was successful. So I would watch your clock no matter what. The worst case scenario is you do it too early. And well, the worst case scenario is you lose your appeal. But I'm saying the worst case scenario is that you do it too early and they kick it back and you're like, oh, I have egg on my face. But I would definitely go from the date of the first order. I also had another case recently where it wasn't my case. Sorry, someone just messaged me and asked me a question, and but it was the same thing. The court put the wrong caption at the top, but the content was correct. And they were like, "Oh, well, this isn't the right case, so this doesn't start my clock." And da, 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 da. And I was like, "No, absolutely not. It does start your clock." And case law, is says the same thing because that's just a clerical error. And so the date that it was filed was still the operational date. So just be mindful. And when in doubt, either, call a trusted attorney friend, or honestly, I say that, but you don't want somebody else's, decision on it, or thoughts on it to really guide you ultimately, because it's your name on it and it's your appeal to accidentally lose jurisdiction over. So I would say when in doubt, file your notice.
I don't see any pending questions. I do see a comment in the chat that went directly to us. The comment is a petition for habeas corpus for belated appeal filed in the trial court can overcome a failure to file a timely appeal from a TPR final judgment.
Absolutely. And you know what? I want to say something about that too, because that's a really good tool. And that's a little bit, I think, even more advanced for what we're talking about here. But doing that, or doing a motion for extraordinary relief, or another post-judgment motion like that, a motion for fraud on the court. Sometimes, if you completely miss an appeal, an appellate window, and you do one of those things, you can then appeal the order from that motion, right? So your habeas corpus in the trial court, your extraordinary relief, your I'm blanking on the number, but it's in civil, it's 1.540, fraud in the court appeal, or motion, excuse me. If you file those motions, then whatever you have included in there and whatever, is addressed in that final order can be brought on appeal. So that's a wonderful point, and I'm glad you mentioned it, Jorge, actually. Thank you.
Right. There was one question about the recording. I answered it in the chat, but just letting everybody know that we are recording. So if you registered, you're going to receive the link via email, and we'll also be posting it on YouTube. There is one more question that came in. It's a
Sure.
denial of intervention into a dependency case by a participant appeal able by cert or as a final appeal.
So that is a great question. It would be a final appeal as to the person who had the denial, um, typically, right? So and which is an easier avenue to go than cert. However, sometimes I have seen dependency courts thinking or excuse me, appellate courts thinking that it is non-final. So if you try to do it as a notice of appeal, and if the court decides that it is actually should belong in cert, it will change it. And there's case law, I don't have it pulled in front of me, that requires the appellate court to treat something before it as the thing it should have been, essentially. There's a Latin phrase for it. So if you file certain, it should be final. They'll treat it as a final appeal. If you file something that you think is a final appeal, right? So as to your client, a denial of intervention, for example, which should have been cert, by the way, I do agree with that. But if you file that as non-final, or excuse me, as a final appeal as to your client, and they decide that it's cert, they'll treat it as cert. The only caveat there is if your appellate court is going to treat it as certain, you haven't really told them about irreparable harm in your appeal, you're a little vulnerable there. So, you might want to throw it all in there if you're just unsure. But that argument's gone both ways in the court, right? Final as to that party versus, oh, they're not a party versus, well, the case is still ongoing. And that was the issue that happened in Kaplan, that she attempted to intervene. It wasn't accepted. She tried to file an appeal. And while that happened, the court kept going with the termination, and then the appeal was moot. So strategically, you might want to do cert so you get it all in within that 30 days.
All right, double checking. I don't see any other pending questions, so we can move on. I do have the poll ready to launch, so let me know
Great.
when you want me to launch it.
Yeah, please do. We have 15 minutes, I think. So if any of these topics speak to anybody, please let me know what you'd like to hear
So
about.
I don't launch it. All right, so the way this one works is you get to rank. It's supposed to let you rank, but right, I'll let you know what percentage we're at when we're close to 50%. So
This is our first choose your own adventure training.
I love it. Taking me back to my childhood, right?
right, so we're at 40%. Let's give everybody a few more seconds. Gonna close it out in three, two, one. And let's end the poll and let's see who the winner is. I'm sharing the results. You should be able to see it on your screen, but let's see. Part A got, as far as number one rank, it got 11 votes for 20%. Part B got 26 votes, 48%, which is probably means that's the winner. So
I think.
it looks like the number one ranking goes to Part C with 48% of the vote at 26 votes. And Part B would be record and evidence preservation.
Okay, so my understanding is part B1. I'm trying to look at it on my screen. It's a little tiny. Okay, understood. So I will jump down to that. Just know that I had prepared all three. So if anyone has questions, feel free to reach out to me afterward too. Um, okay, so we will hit part B. Give me just a moment. Um, pull down my notes. Alrighty, part B. Stays pending review. This is a big one. This is a big tool, actually. I really like this. When you appeal, does anything stop the trial court's order from taking effect? Usually not. There's a rule 9.146C that sets a default. Taking an appeal does not operate as a stay. That means a hold, right? It does not operate as a stay in a dependency case unless the court orders one. There's one important automatic exception. A termination order that places a child with an agency or the department for subsequent adoption is suspended while the appeal is pending, though the child stays in custody under that order. And I know that doesn't always happen in practice, but that's authority. So in a case called Enri MAD, that's a second DCA case from 2002. That spells it out. And the reason is you don't want a child adopted and then have the termination reversed. It's popping up more and more, especially in ARC appeals, and the appellate courts are mooting the appeals. So this is something that is currently kind of being it's big in our appellate nerd world, but it's something to set up and take notice of because there is case law that says that it kind of shouldn't be happening, but also it's being allowed, and then the appeals are being mooted by the appellate court. So it's definitely something that you want to look out for. But for everything else, you just have to move fast, which is why earlier I mentioned I would do cert if you're denied intervention because once it happens, it happens. So you move first in the trial court, which keeps continuing jurisdiction to grant or deny a stay, quote, after considering the welfare and best interest of the child. So notice how that standard folds into the child's interest and the usual stay factors of likelihood of success and harm. So when you ask for a stay in dependency, there's another thing that you have to prove. So typically with stays, you show likelihood of success on the merits on appeal and the harm if the court does not grant the stay. You have your third prong about the welfare and best interest of the child and dependency. The trial court, once it decides on that motion, if it denies, then you can ask the appellate court for a stay, but only after you have asked the trial court. The key there is ask. Sometimes you can't wait for an order, and the appellate court gets that. Use it very, very sparingly. It's kind of like a wink, wink, but you can tell the appellate court like, hey, the harm is big. We can't wait for the trial court here, and sometimes that can work and does work. So don't ever assume an appeal freezes anything. If you need the order held, file the motion, start in the trial court, lead with child welfare because that's the lens that the rule tells the judge to use. And like I said, if there's some danger or emergency, you can file contemporaneously in the appellate court for a stay, noting why, but reserve that for your true emergency issues. Um, and so the next little thing I want to talk about is if you build your, we're kind of bumping around here, but the evidence versus demonstratives. So if you build your argument on a chart, a summary, a timeline, those don't typically get admitted as evidence, obviously, but if you don't mark it for identification and include it in the record, just like your denied exhibits, you can't rely on it. And sometimes those things are wonderful for the appellate court. You can pop those right into a brief and see a beautiful timeline or something. So a demonstrative aid, something used to help a witness or a fact finder follow testimony, that's not evidence. So Rule 0.3400 will not let unadmitted demonstratives into the jury room, right? So that's in criminal. It kind of follows that same idea. So the appellate consequence is right there in a case called Ivy Chase. A document that was identified but never admitted into evidence cannot support a judgment. So draw your line consciously at trial. If it illustrates testimony, you can use an aid. You don't have to get it in for the appellate court, but you can if you mark it for identification. But the moment you need a fact finder to rely on its contents, which is typically why you use a demonstrative, you must lay that foundation and move it into evidence or otherwise get it marked as an exhibit. So there's a checklist in a case called Pierce v. State, which is a criminal case, but it's very helpful because the checklist is accurate description, helpful to the fact finder, qualified witness, tied to evidence. And remember, testimony is evidence, tied to evidence, and not unfairly prejudicial. Okay, so that matters just as much in a bench trial on appeal because the appellate court can only review what's in that record. So when in doubt, move it in or at least ID it. And then notices of filing and supplementing my record. My favorite fix if you're still in litigation before it gets to me. This is the umbrella over everything we've said about preservation. There must be a record, making it as a trial attorney's job. The trial court's decision carries with a presumption of correctness. The burden is on you to demonstrate error. So there's two practical tools. If you need a document in front of the court, get it into the record before rendition. You can even file it with a notice of filing. I've looked at cases that are kind of in that gray area where something's been entered, but we're not in appellate land yet for the record to start being prepped and for the directions of the clerk. And I'm like, oh, do a notice of filing. Just notice of filing XYZ and attach it and get it in there. Notice of filing proposed order. If you see that a judge adopts an order verbatim 5 minutes after it's sent over, you know there's been no independent judicial discretion in that order. But how can you prove that on appeal? Because everyone's just emailing their proposed orders. File those proposed orders so you can show the email was sent 5 minutes before the court entered the order and the court adopted this verbatim. That can be error on appeal. So notices of filing are very, very helpful. Um, and then second, if you're in the appellate court, right, and you notice something's missing, Rule 9.200 sub F lets you supplement not only to fix a clerk submission, but to even add an item that your appellate argument might need if you determine that it's not in there and it could have been, right, if it's in your record, but the clerk doesn't put it in. So there's a hard limit though. It cannot incorrect inadequacies which result from a failure of a party to make a record below. So just remember that like we've said, our running idea is that the record is won or lost, or the appeal is really won or lost on the trial level as far as what the appellate attorney can successfully argue. And then trying issues by consent, we talked about that. So I'm actually going to kind of skip over it a little bit, but it never, never, never hurts to say, my client does not consent to trying this, but we will defend ourselves because the court is choosing to continue with this line of I want to say line of questioning, but with this topic, right, with this issue, with this legal issue. So if evidence comes in on an unpleaded ground and no one objects, that could be tried by implied consent, excuse me. So that's just important to consider. And again, I just think the running idea is don't be shy about ensuring that your objection is on the record. There's also something called invited error. It's a close cousin of preservation. If you draft an order, you cannot take advantage of any error in that order on appeal. So if you invite the error, if you do something that allows the court to do something, and then you can't take advantage of that on appeal. So there's a Supreme Court case called Perlow, P-E-R-L-O-W, that talks about that. And then there's another case, Enri T.D., that talks about it in the dependency context. There's no bright line rule in adopting a proposed order, but what matters is the independent decision, as I mentioned before. So make sure you get those notices of filing in to protect yourself. And then the judicial notice pitfalls. I think everybody's pretty familiar with this. I have like 1 minute, but I just wanted to mention you can't just have a judge take judicial notice of the entire court file, and the appellate courts won't honor that. There's always hearsay within there. You can actually correct this even by just saying, subject to, the hearsay rulings that the court made in this order or whatever. So we've had a case before where we had a prior hearing and then a new judge. We asked the judge to take judicial notice of what happened in that prior hearing, and we made sure to be clear that any sustained objections, any hearsay, we had the court confirm to us would not be considered when it reviewed this. And that's sometimes how you can protect that. But I know probably most of you know how to use judicial notice. I just wanted to make sure you remembered to tell the court to ignore certain things if you're trying to do kind of like a broad judicial notice rather than document by document, because that won't fly on appeal. And I think that that's it for my section B. I flew through. But the line that ties this entire CLE together, I think, is the standard of review will ultimately decide who wins at appeal. The record decides what the standard has to work with. And for an indigent party, for someone who has sidebars or things that aren't fully in the record, protecting the transcript, rebuilding it the right way is the difference between an appeal and an affirmance that you never got to argue. So with that, I think I am finished. Unless there are other questions, Robin and Jorge, I can let you take over. And thank you guys very much for listening.
Great job, great presentation. I don't see any pending questions yet. While we wait for people to drop their questions, I'm going to take that opportunity to drop the CLE code in the chat. I'm going to read it out loud. CLE code is 2605724N as in Nancy. I will also drop the reminder. You're going to get everything through email, so don't worry if you miss out on this here. I'm dropping the reminder for the next webinar for the series happening July 15th. You will find the registration code there. The webinar is You Can Help Adoptions Succeed by Spotting Issues Early. I also dropped the link for the monthly series, so bookmark that link. You're always going to find the recent webinars there, the recordings and materials, and you will also find links to the upcoming webinars so you can register. That way you don't have to go through a million emails to find them. So there is one question. Let me pull it up here. The question is, case plans are supposed to be narrowly tailored to remedy why the case came in. Many judges allow the department to put in housing and employment as case plan tasks, but those were not reasons in a plea or found in adjudicatory hearing. I make objections, but they are overruled. What is the best way to challenge the JR order on case plans?
I think that's a wonderful question. And I would say that is irreparable harm. So there's a case called RR versus DCF. It's 338 Southern 3rd 1026. It's a third DCA case. And you can use that case to kind of build your, start researching in Westlaw or Lexis, but changing the case plan goal is irreparable harm. And the quote says, this circumstance constitutes irreparable harm sufficient to meet the jurisdictional prerequisites for granting certiorari relief. So you do have an immediate resolution there. And then BD versus DCF is another third DCA case. So apparently down south they like these. But that was a disposition adopting a case plan, and that was considered final and appealable. So you might have, depending on the content that is actually within your order, the court may treat it as cert, may treat it as a final and appealable order. Nonetheless, I would get that in front of the court because whether it's cert or final, you have 30 days.
Right. Let's see if I don't see any pending questions in the Q&A. I see a comment, outstanding presentation on behalf of Pills and for 2 more days. Janine rises, thanking you for the CLE and help us upgrade our trial record for appeal. Janine,
Oh,
I'll see you
thank you
later.
very much. And I have my contact information here through Florida's Children First. So if anyone has questions later, and that is my work cell, please don't abuse it. But if you have questions, you can reach out to me there too.
Right. I see a lot of thank yous, and I had to reciprocate. Thank you. Amazing job, Dayna. Thank you, Robin, for helping organize this series. Thank you, everybody that joined us today. So I guess we'll see. With this, we're wrapping it up, and we'll see you, everybody, at the next one. Have a great rest of your day.
Thanks, everybody.